Überseering was a Dutch company that was founded in Netherlands. However, all of their shares were bought by two German citizens, and the company made business mainly in Germany, having also the headquarters there. This was possible because of the freedom of establishment, one of the fundamental rights of the European Union. Überseering bought a land and built a plant in Düsseldorf, Germany, for which they hired another German company to renovate it. However, this company, Nordic Construction Company, which we will refer to as NCC, made a complete mess. Überseering wanted to demand the NCC, so the mess builders, in front of the German tribunals, but they were denied. And you might be asking yourselves, why didn't the German tribunals accept it? Simply, they claimed that non-national firms didn't have the power to present an argument against a German company in a German court. As Überseering did not agree, they went up and up to the Federal Court of Justice against this law, so that they could demand the NCC for the effective work. The Federal Court of Justice from Germany raised a question to its superior, the European Court of Justice. This is known as a preliminary ruling procedure, a member state's tribunal requesting on the interpretation of a certain European law, which, in this case, was the freedom of establishment and what it meant for non-national firms. But before going more into the case, let's see which rules were involved. There are two types of law that were in conflict: the German law versus the European law. German civil and case law states that a national court can deny a claim made by a company if it is not national, as it has no legal capacity in Germany because it was, and still is, incorporated under the Dutch law. So, if you're not a German firm or citizen, you don't have any legal capacity in Germany. That means you cannot be a part in a legal procedure in that country. So the main question is that in accordance with the European Union principles and laws? Well, clearly it's not, as it attempts to one of its fundamental rights, the freedom of establishment. More specifically, it is against the Articles 43 and 48 of the European Community Treaty, which respectively say: restrictions on the freedom of establishment of nationals of a member state in the territory of another member state will be prohibited. Such prohibition will also apply to restrictions on the setting up of firms or branches. Firms formed in accordance with the law of a member state will be treated in the same way as firms who are nationals of member states. That's all beautiful wording, but can we take something clear from this? Not really, especially if we're talking about the legal capacity of foreign firms. The problem is that the EU law is not specific enough. Therefore, throughout Europe, to determine which commercial law is applicable, we have two existing theories: the real estate theory and the incorporation theory. The real estate theory states that the place in which the company makes business will determine the commercial law applicable, followed by countries like Spain or Germany, and much more restrictive with the freedom of movement. On the other hand, the incorporation theory says that a firm will maintain the same legal status no matter where it does its activity. A more liberal theory followed by the UK and the Netherlands. Because of this, when the question was raised, there were two sides: the ones who believed that Überseering had legal capacity and the ones who didn't. Überseering, the Netherlands, UK and the EFTA, European Free Trade Association, and the Commission were in favor, as they believed it was similar to the Centros case, in which the European Court of Justice wrote that a firm founded in a member state could establish a brand anywhere in the European Union under the freedom of establishment. On the other side, Spain, Italy, Germany, and NCC stated that Überseering didn't have this right. They said that the European Community Treaty and the freedom of establishment didn't state anything about legal capacity of a firm, and therefore, national law and negotiations between member states should prevail. But which European law principle was eventually the basis for the final decision? Without any doubt, the judgment was based on the freedom of establishment and on the binding precedent of the Centros case. As it was a preliminary ruling, a precedent has the binding interpretation, meaning that it must be applied in the whole European Union for similar cases. Also, the incorporation theory prevailed, which brought a deregulatory competition between countries of the European Union to attract the incorporation of firms. In the end, and 6 years after this procedure had started, the European Court of Justice made a preliminary ruling stating that the refusal of a member state to recognize the legal capacity of a firm incorporated in another member state is against the freedom of establishment and the Articles 43 to 48 of the European Community Treaty. So, talking plain, this means that any firm founded in a member state and still incorporated, there must have the same rights and obligations as a national firm. Amongst other rights, it must have the same legal capacity as a national firm and can be a part in a legal procedure. Focusing in our case, it meant that Überseering could now demand NCC for the costs and damages caused by defective work in the German court, and this national court had to accept Überseering, a Dutch company, as a part in the procedure. From now on, German civil law must change, as European laws are above national laws, to allow non-national firms to have legal capacity. And, as it is a preliminary ruling of the European Court of Justice, it must be applicable not only in Germany, but in the whole European Union, because its decisions are meant to have a unitary interpretation of the European law in all member states. This means that any company incorporated in a member state has legal capacity in all the member states, no matter what the national law says. Therefore, in conclusion, Überseering case together with Centros case made a difference in the organization of the European Union and, more specifically, in its member states' law, as they were now forced not to differentiate between national law and non-national firms and particulars. Finally, after 6 years of judicial procedure, Überseering could not now demand NCC for making a mess with their plant in Düsseldorf. But be careful. This does not mean Überseering won this demand. It only means Überseering, a Dutch company, could sue a German company in German tribunal. Hope all this trouble was worth it.